Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Yesterday we provided an update in the Idaho versus Kohberger podcast, which has, since the beginning of the case, looked at the documents on the court record as well as in the case summary page maintained by the clerk of court to provide you with brief 5-minute or under episodes as to what a particular document includes, where it's located, so that you can go onto the docket and read them for yourself. The document that I reported on yesterday in the podcast has given rise to a question concerning: did the state of Idaho just advise the public in this public document that one of Mr. Kohberger's expert witnesses is no longer involved in the case? The way that the particular sentence in this motion reads is a little confusing on the one hand, but on the other hand, the only way, in my opinion, to make sense of what it says is that the state has advised that there is a member of the defense team's expert witnesses who is no longer involved in the case. Let's take a look at what this motion says. If you go to the court docket for Idaho versus Kohberger, and here's the link for you to do so, go to April 25th, 2025. It is the motion to seal, state's motion for examination of defendant pursuant to Idaho Code Section 18207 and for an extension of time to complete rebuttal penalty phase expert disclosures and declarations and exhibits in support. This is a very long title. Remember, a motion is an application for a court order. This is where one of the parties is going to Judge Hippler and asking for the remedy of an order to do what the party, here the state, is requesting. Secondly, there's multiple things that are being requested here. First, this is a motion to seal another motion, the motion for examination of defendant. There are declarations and exhibits in support of that motion. 2 of them we see here filed under seal on the case summary page. They are declarations, including from the defense counsel who signed this motion, Mr. Hurwitz. Then there's also intermingled in this a motion for an extension of time to complete rebuttal penalty phase expert disclosures. The deadlines to submit penalty phase expert witness disclosures is contained in the October 9th, 2024 pre-trial and trial order rendered by Judge Stephen J. Hippler. The expert witness disclosures appear at the bottom of pages 2 and the top of pages 3 of that October 9th, 2024 order. With that said, let's read what this motion says and get to the part where the state is appearing to say that a defense expert witness is no longer involved in the case on behalf of Mr. Kohberger. Page 1 begins by saying, "Come now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby moves the court, pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code 74124B, for an order sealing the state's motion for examination of defendant, that is Mr. Kohberger, ladies and gentlemen, pursuant to Idaho Code 18207, and here's the second request, for an extension of time to complete rebuttal penalty phase expert disclosures, as well as the declarations provided in support of this motion, filed herein for the following reasons. So we see here on page 1 where, amongst other things, the state of Idaho is setting forth the legal authority that allows Judge Hippler to seal documents that would be otherwise discoverable by the public and placed on the public docket. Page 2 goes into what's called the good cause. Having cited the legal authority, now the state explains why these documents should be under seal. Page 2 says the following. The motion, declarations, and accompanying exhibits reveal personal, private information of defendant. In parentheses is cited Idaho Code 74124B as legal authority for that statement, and affects his privacy interests. In parentheses appears Idaho Court Administrative Rule 32G1, standing for that proposition. Then the state says, specifically the filing reveals mental health information about defendant, including 1, psychological, 2, psychiatric, and 3, neurological information and diagnoses of defendant. Again, this is referring to Mr. Kohberger. The next paragraph is the paragraph that seems to suggest a defense expert witness is no longer involved in the case. It says here, in addition, the state has redacted the name of a psychology expert who is longer working on the case. The court should accept the redactions to protect the privacy interests of this individual. So this sentence appears to have a word missing, and the word is no, because it doesn't make any sense, to me at least, by reading the sentence as written. In addition, the state has redacted the name of a psychology expert who is longer working on the case. The second reason why it appears the word no is missing here is because why would the state seek to redact the name of a psychology expert who is currently working on the case? So it appears that in stating here the court should accept the redactions to protect the privacy interest of this individual, it appears more likely than not that what the state has just told the world, because this is a public document, that whatever the name of this psychology expert who has been redacted, whose privacy needs to be protected in this very high interest and highly publicized case, on the grounds that he or she is no longer working on the case. Respectfully submitted this 25th day of April 2025, Joshua D. Hurwitz, Special Deputy Prosecuting Attorney. If you have any thoughts, any comments on what this document stands for, I really would appreciate hearing them. Please list them here. All of your feedback is greatly appreciated. This will now conclude this episode of the Indie Zone. Thanks for joining us here today.